everyone. I'm attorney Donna DiMaggio-Berger, and this is Take It to the Board, where we speak condo and HOA. Mark Twain said, "Life is short, break the rules." Apparently, Mr. Twain never lived in a condominium or an HOA. My guest today has encountered many rule breakers in his legal career and has worked with hundreds of community associations who are duty-bound to enforce their rules. Howard Perl is a Florida Bar board-certified attorney in condominium and planned development law and is certified by the state of Florida as a facilitator for continuing education credit courses for community association managers. Howard handles community association arbitration and mediation cases, as well as community association-related litigation. He is a fellow in the College of Community Association Lawyers, which is a national organization with fewer than 175 members who distinguish themselves through contributions to the development of community association law. Howard retired as a major in the Army Reserves after 33 years of service and was deployed to Iraq in support of Operation Iraqi Freedom from July 2005 to July 2006. I'm proud to call Howard my partner and friend for many years. Howard, welcome to Take It to the Board.
Hi, Donna. Those are some nice words you said about me. Thank you.
So, Howard, you were a licensed community association manager before you became a community association attorney. In fact, both of your parents were managers, if I'm recalling this correctly. So I guess we could say it's in the blood. So how long did you manage communities before you became an attorney?
I was a manager for about 27 years before I actually became a community association manager attorney.
You know, I as long as I've known you, I did not know that your professional management career was 27 years.
Yeah, I know. I don't look that old.
So I have to ask, when you were a manager, what was your biggest source of irritation with association attorneys?
That's a good question. And believe it or not, it's easy to answer. I recall very vividly when I was a manager, I hated getting nickeled and dimed for every minute I spent on the phone and or via emails, although I don't know that we had emails back in those days too much with the attorney. I couldn't understand why they had to charge for every minute I spent on the phone. Of course, now that I'm an attorney, I understand.
Yeah, I was just going to say, so do you speak on the phone without charging now, Howard?
Of course not.
Because you're selling your expertise. Actually, you reached the highest level. I think PCAM is the highest level in terms of professional management. So how do you achieve that? And what kind of credentials do you need to achieve that designation?
PCAM stands for Professional Community Association Manager. And it's a designation given by CAI, Community Associations Institute, which is actually a worldwide organization now that fosters development of community associations. I actually received that designation back in 1996, and it's a pretty rigorous process you have to go through. It was back then, and it still is today. Basically, you have to attend a series of about 10 three-hour courses that CAI offers, and then you do what's called a case study, where you actually go to a community association. You study their governing documents, you spend the day in the community, you talk to their people, their manager, their maintenance staff, even board members, and then you're presented with a series of about a half a dozen questions that you have to provide written responses to. So it's sort of almost like a little thesis, and they actually give you 30 days to prepare that document and send it back, and then it's graded, and if it's up to snuff, then you get the designation. So it's a pretty complicated process, and it's something I'm very proud of.
As well, you should be. You know, we've got people listening all over the country, listening internationally. There are many states like Florida right now that currently require that community association managers be licensed. Although over the last couple of years, we've always heard a lot of chatter about whether or not they may deregulate the management profession. Given that you were a manager, your parents were managers, how do you feel about the move to possibly deregulate community association managers?
Well, I'm not going to sit here and tell you that the licensing requirements or the continuing education requirements for a community association manager in Florida is rocket science, because it's not. But it's pretty basic stuff. But at the same time, I think it's very important that managers have a knowledge of pretty basic stuff before they're, licensed to manage community associations. As we've seen recently, These managers are in charge of millions, if not billions of dollars of residential real estate in South Florida. And there should certainly be a minimum requisite of knowledge before they're able to take on such responsibilities. That's my opinion.
I happen to share that opinion because without any sort of even minimal licensing, minimal educational requirements, you really could have somebody graduate high school, I guess, and get a cell phone and a business card, and they're in business.
And they're out there, I promise you.
So, I have to ask you, since I asked you what your single biggest source of irritation with community association attorneys was when you were a manager, I have to ask, now that you're an attorney, what's your biggest source of irritation with managers sometimes?
Well, that's a long subject, but I'll try to narrow it down. No, I'm just kidding. Honestly, I think my biggest irritation is managers not following the association's own established procedures. What I mean by that is, and again, I understand why, managers don't always send a violation letter when they're supposed to. They'd rather talk to the person, they'd rather send an email, and then they send a second email and a third email, and they talk to the person at the pool. And by the time they send it over to us for enforcement, there may have been 4 or 5 interactions with that owner, but nothing official, no letter. So they come to us and they say, hey, we want you to deal with this problem. And it's like, well, okay, what have you done so far? Show me the letters you sent. Well, I sent an email. I saw him in the hallway. And basically, we're starting from scratch when they've been dealing with this problem maybe for months already. So that, that can be a problem.
And to that point, I think that if they've kind of fiddled with it too much before they send it over to us, and in the way that you just described, Howard, that the violator can just tune it out because they've already heard 4 or 5 times that they're violating the parking restriction or the occupancy restriction, and really nothing's happened. So, I do think there's the real risk of over fiddling with it before you talk with your attorney about what can be done.
I agree. And again, look, I understand the manager and the board's position. They don't want to get the attorney involved for every little thing. But at the same time, that doesn't mean the manager can't send a letter. The manager can't send a second letter or a third letter before they send it to the attorney, if that's what the association wants to do. My point is the manager needs to document the violation as opposed to just sending an email or having a phone call.
No, it's a fair point. Of course, I'm sure you can relate, because you were a manager, that a lot of these managers are pressured by boards. You just touched on it, because the boards sometimes say, you handle this. They already know what they're paying the manager for the job, and they don't really want to pick up the phone and call the attorney. But we're going to talk about that in a little bit as to when you need to call the attorney. In our communities, we have rules, lots of them. I think the longest set of rules I've seen so far in one of my communities, Howard, was an HOA with a 32-page rules handbook. It covered everything from parking, pets, nuisance, use of the pool, to acceptable attire in the clubhouse. So my question to you is, do communities really benefit from all these rules, or would fewer rules be better?
I think too many rules are bad because they're just too hard to enforce, and you're going to miss something. And too few rules are just as bad. So, you need to try to strike the right balance. But I will tell you, when I see those 32-page documents that you mentioned, which I have seen, many of them do nothing but recite the provisions from the declaration or the bylaws. And if all you're doing is reciting what's already in the governing documents somewhere else, it doesn't need to be a part of the rules. And I think if associations would take that into account, a lot of the 32-page documents could be 16 pages. Understanding that the board doesn't want to pay the attorney absolutely has to be involved in reviewing rules before they're published. 1, to make sure they don't conflict with anything in the governing documents, and 2, to make sure they don't conflict with any statutes or fair housing requirements or something like that.
So how often do you recommend that a board go back and do sort of a rules audit where they look at the rules and they figure out, what, this is really no longer a problem. We don't need this rule, or this new problem has cropped up and we don't have a rule on the books to address it. How often do you kind of recommend that they evaluate what they have?
Well, I want to address your last comment first. Every time a new situation crops up does not mean the board needs to adopt a rule to deal with that situation. Just because Mrs. Smith's grandson has a noodle in the pool and it bothered Mr. Jones, if you've never had an issue regarding noodles in the pool before, you don't necessarily need a rule regarding noodles in the pool to address one owner's complaint.
Howard, it could be an avalanche of noodles waiting to happen.
Well,
How do we know?
If you don't want to have ramen in the pool, I mean, don't order it. But and again, I just think that rules should not generally be reactive to an individual complaint. As you said, rules are something that should be reviewed. There's nothing wrong with the board or the manager reviewing them on an annual basis. Things change, the makeup of the community changes, who's living in the community changes, the laws change. So an annual review isn't something that's bad, but I would think no more than 2 years should go by before an association should take what I would consider a comprehensive review of its rules and reach out to the attorney to see if there's anything that's changed in the laws that maybe aren't addressed in the declaration or the bylaws that can be addressed in the rule.
You mentioned that sometimes the rule handbook is just a recitation of what's already found in the governing documents. Let's take a declaration of condo, for instance. But sometimes the rules are just brand new rules and the declaration is either silent on that particular topic, let's say pets or parking or leasing, or the rules conflict. Before we talk about enforcement, can you kind of address what happens when you're being asked to enforce a rule and you go back, I would assume, and you look at the authority outside rules, you look to see if there's rulemaking authority, and you also look to see if there's anything that conflicts in the documents that take priority over the rules?
Great question, and it comes up more often than I think us attorneys, want to admit to our clients. Rulemaking is a specific authority that must be granted to the board in the governing documents. Generally, it's granted in the declaration, the bylaws, and the articles. You'll see it in all provisions under the board powers. But if it's in just one, that's generally acceptable. And then there's two types of rules that the board may be authorized to promulgate. The board may be authorized to promulgate rules regarding the common areas. And if that's all it says, the board isn't necessarily authorized to promulgate rules regarding the unit. If the provision says the board is authorized to promulgate rules regarding the common areas in the units or the condominium property, then generally the association also has the authority to promulgate rules regarding units. What do we mean by rule regarding units? No rugs over the balcony, no mats out front, that sort of thing. So the first thing we got to look at is if the board has the specific authority to enforce the rule it's trying to enforce. And that gets into whether they have the authority to go against the common areas and or the units. And many times you'd be surprised. I know you wouldn't be surprised, Donna, but many of our listeners would be surprised that an association is trying to enforce a rule regarding a unit when they have no authority to do so.
But again, tracing the source of authority is the starting point, which is also why I know we both recommend that before you make threats and before you start engaging with an owner that you believe is in violation of a rule, make sure you trace your authority to actually enforce that. Because there's nothing worse than losing face in a battle with an owner.
Well, not only losing face, but if the attorney doesn't do his or her homework and you end up filing a petition for arbitration or something like that, and the other side brings up, hey, the board doesn't even have the authority to promulgate this rule, if that's the fact, you're more than likely going to lose.
Great segue into enforcement. Sometimes boards and managers approach every violation with an equal amount of alarm, but there's a big difference between someone who's violating the rule about storing flammable materials in his or her unit and someone who's parking their car head out rather than head in. Do these types of differences shape the way you approach enforcement and the way you discuss the problem with the board?
And as you mentioned, some violations are much more serious than others. And I've dealt with this case recently about parking head in instead of head out. And to the board members and the manager, this is a violation of the Magna Carta. But in reality, when you interact with the owner, well, there's a pipe that leaks in the back. And when I park in front-wise, it leaks on my car. When I park in back-wise, it doesn't leak on my car. Or I have a bad shoulder that week, I couldn't turn around. That's why you want to look at these, what I consider serious violations and not serious violations on a case-by-case basis, so you don't go running off to the courthouse about something that's due to the person having a bad shoulder that week.
Give me an example of violations that you would consider serious enough that you would advise the board or the manager to kind of skip the regular niceties, the gentle nudging or the gentle reminders. and instead say, this is a serious enough violation. Let me handle it initially.
If the association is dealing with an aggressive owner or resident, somebody who's very belligerent, very abusive with their language and or their mannerisms and or invading personal space, whether it's to other residents, association staff, management, to me, that's a serious violation that needs to be nipped in the bud. Somebody that's dealing with dangerous behavior, maybe they're driving erratically in the community, speeding, running through stop signs, endangering people in the community. If we're dealing with a dangerous dog that jumps at people, or a dog that has attempted to bite somebody. These are what I consider serious violations that need to be dealt with probably more immediately and severely than your general, for lack of a better term, run-of-the-mill violations.
Do you ever get asked the question, is this even a board issue? And let me give you two examples. The first example being two residents, they don't like each other. They're the Hatfields and the McCoys. They're fighting. They're threatening each other. Question is, does the board get involved with this? And second example would be excessive secondhand smoke.
The proper answer is it depends. My favorite answer, it depends.
I knew you were going to say that. The
first one, where you have the Hatfields and the McCoys, if they're just complaining about each other to each other, then I don't think the association necessarily has to get involved. If, however, one of them starts complaining to the association about the other, alleging abuse, bullying, any of those types of things, while honestly in the past we may have taken the position, that's really between the two of them, the association doesn't have to get involved. There's been some recent changes in the laws and the statutes and the case law where the association does have to conduct a proper investigation into those types of allegations. So that's how I would handle those issues.
I agree.
Secondhand smoke, it began to get more prevalent.
It's a nuisance.
It definitely can fall under a nuisance provision. I know our listeners, most of them are probably going to be aware of this, but there's a big difference between a nuisance pursuant to your association's governing documents and a nuisance pursuant to Florida statutes. Every now and then you'll get the owner/attorney, the owner who thinks he or she is an attorney, who says, well, it's not a nuisance according to section 1234 of the Florida statutes. And it doesn't have to be. As long as it's a nuisance of the association's governing documents, then you can enforce it. But again, goes back to what we were talking about earlier. Look in your documents for enforcement authority. Because believe it or not, there are some association documents that do not have a nuisance provision. And there's nothing in the governing documents that gives the association the authority to enforce nuisances. Or if there is a nuisance, it may be very specific. You have to make sure you have the authority to enforce. But if we're talking about secondhand smoke, I think it can be a nuisance if it is actually a nuisance. And before you ask the follow-up question, another one now has to do with marijuana smoke, with medical marijuana. And I have a medical marijuana card, therefore I can smoke marijuana. You can't tell me I can't smoke marijuana. And whether that may or may not be true is a different question. But regardless, it still cannot be a nuisance.
I agree with you. We've been saying for years, you're as good as your documents. So this is the reason why, if you have the ability to amend your documents, and many people think they don't, but really it does require some creativity. Certainly with the states that allow online voting, it's gotten a little bit easier. But you're as good as your documents. Those are the tools that we're gonna be talking about in a minute here, in terms of enforcing your rules and your regulations. With the secondhand smoke, I can tell you, when I do a document rewrite, and I know you do this as well, Howard, I flesh out that nuisance provision. If one's lacking, I add it. If one exists, and most of my documents have nuisance provisions in them, but they're very bare bones. So I would flesh that out to include things like secondhand smoke. I've even fleshed out nuisance provisions to include things like the police being called out on a frequent basis for issues inside the household, including domestic abuse, or if we believe there's potential drug transactions going on. So whenever boards ask about how to address violations, we need to discuss the enforcement tools in their toolkit. Let's start with the two that don't need to involve you all that much. fines and suspensions. How effective do you think the threat of fines and suspensions are when it comes to getting someone to cure a violation?
Some people, the threat of a fine or the threat of a suspension is enough to bring them in line for whatever reason. They don't want to be known as a troublemaker in the community or whatever the case may be. That's probably the lesser of the offenders. For many offenders, fines don't matter to them, especially in a condominium. Generally you can fine in a condominium, you can post the fines to the unit, but there's no real enforcement mechanism other than collecting the fine at a sale or refinance. You mentioned suspension, so you may be able to suspend the unit owner's rights. And again, depending on how the community is set up, that is something that may or may not be effective. If you have a fob system where you can turn off the fob access to the gym or the library or the pool, that can be much more effective where you have an open community and you can suspend access, but there's no real way to control it. So it really depends on the violator. The boards need to know, but whatever you do, you have to do consistently. So even though we think a fine or a suspension will probably work with Mr. Jones, but wouldn't work with Mrs. Smith, we still have to go through that process with Mrs. Smith if we want to go through it with Mr. Jones.
This past session in Florida, we saw a legislative change that now allows boards and owners in condominium disputes to choose whether to arbitrate or mediate those disputes. What are the respective advantages and disadvantages of mediation versus arbitration?
Arbitration is a process that the legislator instituted a long time ago. And it's got a funny name if you think about it, mandatory, non-binding arbitration. So it's mandatory, but it's non-binding. But at least in an arbitration, you have an arbitrator making a decision. Both sides present their case. They violated the rules because of this. The owner says they didn't violate the rule because of that. The arbitrator makes a decision. Life goes on. In a mediation, mediation is a conciliatory process as opposed to more of an adversarial process where you are not required to come to any solution at a mediation. Many cases can be resolved through mediation. It's certainly a lot more economical, a lot less expensive, and a lot less adversarial. So it really depends on the matter at issue, and it depends on the parties as well. A lot of times these issues between whether it's the association and the owner or something like that becomes personal. And personal issues are something that don't belong in these proceedings. Unfortunately, they are. And if it's a personal issue, you probably have less of a chance of resolution at mediation than you do at arbitration.
I was going to ask you that. So, listen, people want to know what their chances are of succeeding in a dispute, right? Is there one platform over the other that favors the owner in a dispute versus the association? Because again, these associations are corporate entities. Does that way somehow factor in here where it's poor unit owner versus big bad association, or is that
I don't
not
think
a
it's a factor. The only time it's a factor is in arbitration when you're talking about award of attorney's fees and costs by the arbitrator, because the arbitrators do look at it as the big bad association versus the little homeowner. And arbitration awards of attorney's fees and costs are anywhere from 50 to 65% of what they would be awarded if in the same case in litigation.
How often, when you're handling these disputes, are you coming up against an adverse party that is pro se, meaning the owner is representing himself or herself in the proceeding?
In my experience in the arbitration proceedings, probably 80%, if not more, are represented by attorneys. It's not that many that are pro se in arbitration, perhaps because there are pleading requirements and there are certain documents that have to be filed. Believe it or not, I think I come up more against pro se litigants in litigation than I do arbitration for some reason. I couldn't explain that.
How does it play out when you are dealing with a person with, let's say we're dealing with an occupancy or a leasing violation. Owner decides to represent himself. Let's say you're even in litigation and you've gone you've attempted to eject the unauthorized occupant. Does it go more smoothly with a pro se litigant or not?
I will tell you that the Florida Rules of Civil Procedure provide that a pro se litigant is not to be given or treated any differently than an attorney, meaning that they're supposed to follow all the rules, they're supposed to follow all the documents and everything like that. The truth of the matter is, and I'm not saying this is a bad thing, generally judges will bend over backwards for a pro se litigant to assist them with the process, assist them with what's going on, give them the benefit of a doubt, that sort of thing. And I understand why the judges do that. But I can tell you that I've had associations spend thousands, if not tens of thousands of dollars on additional hearings and pleadings and filings and motions that were required because of a pro se litigant. That never would have happened with an attorney on the other side.
So you try to enforce rules. I am sure you get pushback from the violators in the form of an affirmative defense. Can you walk us through the various defenses violators use to justify their actions or their inaction and to basically say to you in the association, you can't force me to do X or Y because of this?
Sure. There's basically 2 or 3 affirmative defenses that you see, over and over. And when you come to some things, they're going to say it's a violation of fair housing laws or housing and urban development laws when you're talking about maybe children or violations of children or number of people that can occupy a unit, that sort of thing. So that's that type of defense you'll see in those kind of cases. But in your general violation case, the 2 most prevalent defenses are what they call estoppel, which I'll go over, and waiver. And basically, estoppel means that the board is selectively enforcing against them. So that if there's a dog in one unit that the board is going after in a no pet community, well, they better make sure there's no dogs in any other units that they're aware of. Because when the owner they're going after says, well, wait a second, there's a dog in unit 2 and unit 3 and unit 4. And by the way, unit 4 is a board member. You can't come after me. That is a classic example of selective enforcement. And the association will very likely lose in that type of a claim. Along the same lines, sort of, is waiver. Waiver is the association was aware of the violation but did nothing about it for a long period of time. There's nothing in the law that says what that long period of time is. And I've seen cases where after 12 or 18 months of knowing of a violation, the association could still go after the violator and enforce it. But if you start to get to 18 to 24 months that the board has been aware of a violation and they haven't done anything about it, then you start to get into the area of waiver.
So selective enforcement, does it have to be, it has to be apples to apples. So if you're going after one person for an unauthorized pet and they say, yeah, but my neighbor has a, bath mat hanging off their balcony railing, that's not selective enforcement, is it?
In my opinion, no. In the opinion of probably 95% of the arbitration cases, I would say no. But there are always that 1 or 2 outliers where either an arbitrator doesn't get it or something else is involved. But generally, I would absolutely agree with that. Now there's exceptions that I'm referring to. For example, if somebody has a dog and their selective enforcement is somebody has a cat, well, the arbitrator is going to look at that as an animal. So to say they have a dog and I have a cat, that's pretty much the same. But like you say, this person has a dog and this person has a mat in front of the unit. Those are 2 separate things, and that's not selective enforcement.
You mentioned estoppel. You mentioned waiver. What about latches?
You mean like the thing that the doors swing back and forth on?
No, like the legal theory that is spelled LACHES, which is another affirmative defense.
Latches just means that it's been so long that that time has passed that it's a form of waiver, actually. So again, if somebody's had the door painted purple for 7 years and all of a sudden the board sends them a letter, that's probably waiver and latches.
So it's a perfect segue because sometimes it is that something hasn't been noticed, and that's the reason why the rule hasn't been enforced. But what about the times when a board makes a decision not to enforce some of their rules because they don't want to spend money to pay the attorney to go enforce it? Is that a breach of fiduciary duty on that board's part if they just say, no, we're not going to spend the money to enforce these provisions in the document?
Are you saying that things like that happen in your communities?
I'm saying it could happen, and we saw it a lot during the recession, yeah. Howard. I know you did. We're dealing with a high percentage of delinquencies, and they weren't enforcing the parking provisions, or they weren't enforcing the pet provisions, or the leasing restrictions.
Well, there's a couple answers to your question. And let's start with consistency being the key. The board can't all of a sudden decide they don't want to enforce the governing documents because it's the president bird who's making the noise or a board member's grandson who's running in the hallway. when they've enforced that previously. If they make that decision all of a sudden, I think they're opening themselves up for issues. If the board wants to make a verified decision or a reasonable decision that, hey, we have this rule on the books, we haven't enforced it for 3 or 4 years, Mrs. Smith was complaining about it, we don't really think it's something that should be enforced anyhow, so we're not going to enforce it, I think that's defensible, okay? And you also have to go back to what we talked about initially. You need to look in the association's governing documents. There's case law out there that actually provides some association governing documents say the board may enforce the rules. And if that's what the documents say, the board is not obligated to enforce the rules. Now, again, they want to deal with that consistently, but some documents say that. Other documents say the board shall enforce the rules. And in that case, I think that puts more of a burden on the board to progressively prospectively enforce the rules without making these arbitrary decisions that they don't want to.
I think that to somebody who's not on the board and they're seeing, somebody parking in the wrong spot, what they don't know is the efforts that may have been made to address that violation. Also, the affirmative defenses you mentioned. That violation may have existed for a length of time where after speaking to you, the decision has been made that it would be very, very difficult and costly with not a great likelihood for success of enforcing that particular rule. So I find often that sometimes the owners, they're not keyed in to this kind of analysis.
I agree. And something else for the board members that are listening to be aware of, just because an association may have not enforced a rule in the past and an owner may have a valid argument for waiver, does not mean that there are not ways the board can institute enforcing those rules, even the ones they've waived, moving forward. There is a way to do that, and the way to do that is to contact your association attorney.
Good plug, Howard. Very good plug. So my dad used to always warn my brothers, sister, and I not to pick fights we couldn't finish. I assume you agree that bluffing in terms of enforcing the rules is not the best strategy. So what do you say to a client who says they want you to send a demand letter just to see if it solves the problem, but they want to go no further if your demand is ignored?
Good point. It depends on exactly what they want you to say in that demand letter. If they just want you to say cease and desist and don't do this and here's a violation or else, I'm generally okay with that. I mean, that's generally what your violations letters say anyhow. But if they want the or else to be, we're going to file a petition for arbitration or we're going to file a lawsuit, and either A, they don't have the authority to do so, or B, my advice is they're going to lose if they do, I would generally tell them not to make such empty threats.
Because what happens when you make an empty threat? You bluff. If you lose the bluff, then I think sometimes the chatter around the pool is that maybe the board's not serious or doesn't have the wherewithal to actually enforce the rules.
Well, anything that happens in an association gets around. And if the association does file a lawsuit or a petition for arbitration against a violator, that gets around, and that can act as a deterrent. And if the association makes these bluffs and doesn't follow through, that can also get around, and that can act as an accelerant for those who want to violate the rules.
So the next question really separates the newbies and the veterans. You know which group we fall into. In terms of figuring out whether or not this is a personal problem that maybe one board member is having, or if this is a problem that the entire board feels is an actionable dispute. And typically this happens, Howard, with nuisance and noise. Back in the day, I might not have, when I was a newbie, may have acted on that immediately. Now I might say, well, let me ask you, does anybody on the board live next door to this individual? Do you, Mr. or Mrs. President, live next door? How often are you told there's a problem with a particular violation, only to find out that it's really a personal dispute between a director and his or her next door neighbor?
Well, like you, I'm sure, when I was a newbie, I learned how to deal with this the hard way. And you have to ask these questions. board members will say, well, what difference does it make if I'm a board member or not? I'm an owner and I have a right to have the rules enforced like anybody else. And they're absolutely correct. But you need to look at perception, because as a board member, you're there to look out for the community. And as you have by statute a fiduciary duty to the association, which means you have to put the association's interest above your own interests. So yes, these questions need to be asked. If it's a dispute and there's a board member on one side, maybe we see if the neighbor on the other side has the same issue, or if the neighbor above, or if the neighbor below. If a board member is complaining about noise and nobody of the other 3 units is complaining about noise, then I think you need to be a little circumspect about moving forward.
Because there are different sensibilities. Noise is a tough one. I mean, we can go out. I'm sure you've done it before. Get the level, the decibel level checked. But noise is a difficult violation, in my opinion, because it could be a princess and the pea situation for a particular owner that's highly sensitive.
I agree. And just to give you an example, dog barking. All right, dog barking in a condominium, and there is case law that says just because a dog barks does not mean it's a nuisance. Dogs are animals. Animals are going to bark. If you walk by the unit and the dog barks for 10 seconds or 20 seconds every time somebody walks by the unit, that's not necessarily a nuisance, because you live in a condominium, dogs are allowed, and dogs bark. The dog is barking incessantly on the balcony at 2 o'clock in the morning for 20 minutes. That's more a nuisance. So you need to look at these on a case-by-case basis.
Yeah, it's a good point. I mean, it's the same thing with smoke. When we talk nuisance, we're talking excessive secondhand smoke. And to your point, it needs to reach a certain level to rise to the level of a general nuisance.
Agreed.
So during the recession back in 2007, we often discussed with our clients, Howard, that some owners weren't paying because they chose not to do so. It might have been a strategic default situation, and others weren't paying their assessments because they simply couldn't. Isn't there a similar analysis when it comes to people with mental illness in our communities who may be violating the rules because they're grappling with a mental illness? It's not that they want to violate the rules in some cases. It's just that they really cannot control their behavior to comply with the rules. How do you approach those violations?
I'm actually dealing with several of those instances right now. And depending on the severity of the actions we're talking about, one option is for the manager or the association to contact social services and see if and have them come out and check on the person and see if the person should be what they call Becker acted, meaning they put them under observation, I think, for 72 hours. And sometimes that'll result in that person being removed from the community. More often than not, they're under observation, then they end up coming back to the community. Unfortunately, the only way we have to deal with it right now is either by a petition for arbitration or by, injunctive relief if it's that severe, to at least try to put maybe the person's spouse or whoever is living in the unit on notice of the severity of the situation to hopefully get them to address it.
It's important to communicate, though. I think you would agree. I had a situation a couple years back. Manager contacted me and said an elderly female owner was sleeping in the clubhouse at night, and it was irksome to the board. They didn't like it. I remember just thinking to myself, that's strange. They were thinking that she was doing this to be a nuisance. Please send her a demand letter telling her to stop. I said, this just doesn't seem right. Why would she, and I asked questions. How long has she lived there? Has she, ever been a problem before? Are they current in the payment of their assessments? And after doing a little bit more digging, and I held off writing that demand letter because something didn't feel right to me. Anyhow, we did reach out, and this is where having emergency contacts, updated emergency contacts for owners, particularly elderly owners, becomes important. We did reach out to an adult daughter, and she said that there was a domestic abuse situation that was going on in the unit, that her father had been abusing the mother, and at night she was sleeping in the clubhouse. And to this day, Howard, I am so thankful I dug and did not dash off a demand letter to somebody who was actually the victim in this situation.
And that's a great point. And I hope that the board members and the managers that are listening to this podcast will remember that point when, as the attorneys, We keep asking questions. We keep digging. You get the email from the manager of the board member, hey, we got this violation. We want you to send a letter. Well, now doing our job, we start asking questions. What have you done previously? Let me see the previous letters. Do we have the authority? The questions that you ask. And unfortunately, sometimes the managers and the board members get a little annoyed with the attorney. They say, look, I just want you to send a violation letter. But remembering that we are general counsel, and the word there is counsel, we need to counsel our client as to some of these other issues that you very, prudently pointed out.
And I think that board in question also was grateful that we took a slower approach and we really figured out what was going on. Ultimately, the demand letter went to the husband. So at the outset, I mentioned your military service, Howard, and thank you so much for that service. I got to ask, doing what you do for a living now, did your military training, did it shape you? Does it help you in any way when it comes to litigation and rules enforcement?
I think it does. I mean, anytime you have military training, it shapes you. You learn how to deal with adversity. You learn how to be cool under pressure. You learn how not to let people bother you. You've been to some of these board meetings as well as I have, Donna, where you have some really obnoxious owners, and it could be very easy to get obnoxious back. But that's not something we want to do, and not something we should do, or not something the board should do. It's another thing I always try to counsel the board on. Don't stoop to their level. Board members are people too. And if they're constantly being barraged with insults and foul language and being accused of bad things, it's only natural for them to reach out and hash out back to the person. But we don't want them to do that. We want them to raise above the fray. And I think my military training has helped me with that. And obviously, going into any board meeting is not an issue based on what I've been through.
Well, and I was going to say, also, I've heard you do your drill sergeant shout, so I'm sure you can. I'm sure that comes in handy when you need to quiet people to start the meeting.
I can control a room if I have to.
One last question. What do you think the biggest mistake volunteer boards make when it comes to enforcing their rules?
I don't want anybody to take this the wrong way. Because we always want to try to work things out in as amicable a fashion as possible. But I think the biggest mistake boards and managers can make is letting a problem become a bigger problem by trying to be a nice guy or a nice girl and resolving the matter informally, as opposed to escalating it to a formal letter, whether that formal letter is from the manager or from the board or from the attorney. Yes, we want to resolve everything amicably, but you need to take a stand when something needs to be enforced and start enforcing it with documentation.
Yeah, I was going to say, it sounds like you're suggesting just a level of formality so you can wrap it up and close the matter and set it aside.
Absolutely.
Thanks for joining us today. Don't forget to follow us on your favorite podcast platform. Leave a review so more people can take it to the board, and visit takeittotheboard.com for more information.